SJC-13560, Stephen Clark et al. Versus Andrea J. Campbell, Attorney General et al.
Great. Okay, Attorney Daly.
Good morning, Your Honors, and may it please the Court, Ed Daly and Elisa Poppy, on behalf of Mr. Clark, who's joining us today in court, and other interested voters, registered voters in Massachusetts, who oppose the certification of ballot initiative 2312. And I know this Court has heard at least 2 different ballot initiative cases this week and is well versed in the relatedness analysis, so I'll just get right into it. The critical question for the relatedness issue is whether the petition offers a unified statement of public policy to the voters of Massachusetts, such that those voters can either vote yes or no. It avoids the untenable situation where a voter is presented with 2 different policy issues, but only 1 vote to decide both. And that's exactly what we have here today, a petition that presents 2 distinct statements of public policy. The petition's titled, "An Act to Require the Full Minimum Wage for Tipped Workers with Tips on Top," and it advertises itself as a petition about the minimum wage.
Do you take the title to be the statement of the unified purpose or policy?
I think because there's no other statement of unified purpose or public policy, the title is where to look. And
Have
that's
we
what's
ever
telling voters.
said how it is that we're to determine what the purpose or policy is?
Well, I think in several cases, including the opinions of the Justice's case in 1996, the court looks to first the title of the petition, because that's what the voters are going to be looking at. That's what's in front of them. That's what they consider in the voting booth.
And
then,
is that the end of the inquiry, or do we look further within the text of the initiative to determine what the policy is?
well, the court can certainly look further into the text of the initiative, and oftentimes there's statements of purpose in these initiatives which tell the voters the purpose of the initiative before them. There is no statement of purpose here, so the voter is left with what's in front of them, which is the title, and that is an act to require the full minimum wage with tips on top, or for tipped workers with tips on top. And the issue here is that although the petition advertises itself as a question about full minimum wage, it's really presenting 2 different issues on the menu for voters. And that first issue, of course, is about minimum wage, but the second is about tip pooling. Concerning that first issue,
They're really substantively interrelated, though. I mean, I understand you can tease them apart to a certain extent, but so you've got a restaurant operating, and the people dealing with the public are, getting paid tips, and the people in doing the dishes are not. But the success of the restaurant is interdependent. It just seems to me these are awfully closely related when we look at the different cases we've decided. The only case that's even remotely close to it may be the education case, but I think you're really swimming upstream here. Tell me why this close interrelationship is really separate.
well, because there's actually not really a close interrelationship at all.
Oh, but the restaurant's profits and operation are all caught up in how you pay the people who work there.
Your Honor,
go
this
ahead.
petition wouldn't just affect restaurants. This is any employer that has tipped workers or any service employers. This could be a hotel. So the workers of the hotel would be required to remit tips back to anybody from the landscaping crew to the people who maintain the pool. So this isn't just an issue about tips and wages in restaurants. But even if we were just to look at the issue of tips and wages, those are 2 separate things with 2 separate relationships.
Doesn't this deal with the consequences of phasing out the tipped scale? Because as we elevate the pay and get the servers, in one example, to a minimum wage, we have to deal with what happens to the tips thereafter, correct?
But, Your Honor, this isn't a consequence mitigation case, because these 2 provisions or these 2 questions for voters can exist completely independently. So this isn't the type of case where it's an enabling case or a consequence mitigation case. There's no overall scheme. And I just want to focus on the purposes.
There are two existing statutes, right?
Correct.
The existing statutes allow you to pay less than the minimum wage, but they also prevent you from passing the tips on to the backs. I'm describing them improperly. In the hypothetical of the restaurant, the people who were doing the dishes or otherwise in the back room. So those statutes are interrelated. And now this new statute will reallocate those rights. So they're dealing with the existing statutory law too.
Well, so those statutes are actually not so much interrelated, but they are separate because tips and wages are separate issues, and they're separate relationships at play here, where the relationship between employer and employee, that's the wage relationship, what an employer must pay an employee. And that's the relationship that's affected in the purpose of sections 1 through 5, the minimum wage statute. So the fact that the minimum wage statute, the fair minimum wage statute says, hey, don't look here if we're looking at tip pooling, that's in a different statute. It doesn't bring those together. It actually separates the two statutes because they reflect different relationships and different purposes. And that's clear from looking at the operation of sections 1 through 5. That is asking voters, do you favor increasing the minimum wage for a certain category of workers? That's its own question. But of course, those workers are already guaranteed to receive the full minimum wage. So the question is really, do you favor eliminating the tip credit, what an employer is required to pay in terms of a minimum wage, irrespective of tips received? And that's a separate economic relationship, as I just mentioned, between the employer and the employee. So when you look to this second proposal, the second issue, and it's not as well advertised to the voters, it's not in the title of the petition.
Can I stop you there?
Of course.
If it were, if the title of the petition and the name of the proposed act had said an act to require the full minimum wage for tipped workers and to permit employers to create a tip pool that would be shared among tipped workers and non-tipped workers, would then all the provisions be related?
They would not.
Why?
That would address the issue of whether this petition is misleading, but it does not go to the relatedness of the petition because the two purposes are separate and they're mutually.
So for me, at least, it will be helpful to then understand, because I thought you said that the purpose can be gleaned by looking at the stated purpose or title of the act. But now it seems to me you're saying that the purpose is to be determined by looking at the individual provisions.
Well, the title of the act it informs the voter what they're voting on, and this presents the voter with a question about minimum wage.
Yeah, but how do we determine relatedness for Article 48 purposes? It's not based on the title of the act, is it?
It's not just based on the title
Right,
of the
it's
act.
about whether or not there's a common purpose as to which each of the component parts can be said to be germane. Isn't that the test that we've articulated?
That's correct, and there is no common purpose here because each
Because
of the
you're
provisions go to
saying
something.
not allowing the employers to take the tip credit is completely divorced from and independent of the idea of tip pooling. Is that your position?
Well, tip pooling, Section 6 could survive and exist by itself if Sections 1 through 5 never existed. It's totally independent. It does not depend.
Where in our case law do we have that test where we say if a provision can exist totally independent from, albeit overlapping with the other one, that it violates Article 48?
I think that's the key of the mutual dependence test, is that if both of these provisions.
Where is that in our jurisprudence? Where is that mutual dependence test separate and apart from the relatedness test articulated in our jurisprudence?
I think that's in Anderson. Footnote 8 addresses that the fact that you can have a certain element that's common, or you can have a certain connection that does not satisfy relatedness. Because if each of the provisions can survive on their own and function on their own and are not dependent on each other, that presents, and that shows the court that these are truly two different issues that are being presented to the voters.
Well, then let's look at the language of Section 6, because the first clause of it has sort of a dependency relationship with the other portions. It says, provided that an employer is paying all employees a wage that is not less than the full minimum wage as provided in Section 1 of Chapter 151. Why is that not enough to make this not a standalone, independent provision, but why doesn't that create the dependency you're talking about?
Sure, because if sections 1 through 5 did not exist in this petition, if you split these two issues into their own separate petitions, section 6 wouldn't have to be amended at all to be presented to a voter. That's why it's totally independent. And so just because there's some abstract or connection or
But
common
wait,
element.
and then I just hear, I want to make sure I understand what you're arguing. That sounds to me as though the objection is that there are two things joined in one proposal, and that you're requiring that simply, regardless of their logical connection, they need to be in separate initiative petitions. Is that what you're saying?
Well, I'm saying that the problem with this particular initiative petition is that it's joining two dissimilar subjects, two different questions for Massachusetts voters into one petition. This is, it's the issue of hitching or log rolling, where there's one set of voters that may love sections 1 through 5. Think about the restaurant workers at the front of the house. They may say, great, this sounds like I'm gonna get increased minimum wage. That's wonderful. But then you look at section 6, and that says something completely different. That says we're going to be allowing your employer to take those tips away, and actually, and wages as well, if you look at the text, which I actually missed the first 100 times I read this petition, but on the 101st, it says the employer could be permitted to remit any wage, tip, or service charge from that front of the house worker. And so that worker may say, I don't want to do that. I don't want my tips for the hard work I'm doing for the customers to go to someone else, whether it's, and maybe the dishwashers, but it could also be the events crew at the restaurant, or it could be the catering crew, or in-house counsel for a restaurant, who knows? It's just, there's no limit to the amount of, there's a limited limit to the amount of employees that those tips could go to, and that's only the employer or a manager. And so that presents the waitress, the waiter, the housekeeping staff at a hotel with two very different options. And if you take it the other way around and you look at the employer who's looking at this question, these questions, that says maybe they hate 1 through 5. They say that's going to raise wage costs. That doesn't make any sense for the business. But then they look at section 6 and they may say, well, tip pooling and sharing, that doesn't sound so bad. And the reason that those different voters could look so differently at these different issues is because they are separate questions with separate purposes. And that's exactly what the relatedness requirement seeks to prevent the voters from having to choose. They have one vote, but they're being asked to vote on two separate things. And section 6 is also remarkable because it would create a new economic relationship in Massachusetts. Instead of just amending the minimum wage statute, this creates a new economic relationship where employers are permitted to take the tips from a tipped worker and subsidize the back of the house's wages. And that's something that's remarkable because it does not exist under Massachusetts law. It is now saying that you're allowed to take tips, wages, remit them to a tip pool.
Both provisions present a new economic relationship.
So I'd say that sections 1 through 5 amend a current economic relationship.
Well, if you were not getting minimum wage, now you're, the standard minimum wage, and now you're getting the standard minimum wage, that's certainly a new economic relationship, isn't it?
I disagree, Your Honor. I think that adjusts the current economic relationship, and that relationship is between wage payor, the employer, and
So
payee.
you're equivalent over a just versus a new.
No, because there's never a situation.
How about changed?
Changed? It's an amended. So sections 1 through 5 is an act of amendment, whereas section 6 would be an act of creation. Right now, there's no situation, and it's prohibited to require that tips and wages from the front of the house be taken away from those workers and then used to subsidize the back of the house's wages. And
So because it's an amendment to a prohibition, it's a whole new economic relationship.
Here it certainly is, because right now there is no situation where a tipped worker's tips can be taken away from them. And it's important, this is an issue of why the petition itself is misleading to voters, is because the text of the petition, the title, is promising something that Section 6 is essentially removing from them. This is the issue of the rowboat on the river. It's not going down to the same direction. There's two crews of rowers rowing in opposite directions here. It's saying, do you want to have more money in your pocket, higher wages for a certain class of workers? But then this other question that says, we're actually going to do the exact opposite.
Does it matter that Section 6 is discretionary?
It does matter for the relatedness standpoint, because it actually demonstrates why it's a standalone, independent question for voters. It can exist without the requirement or without the existence of Sections 1 through 5.
But since it doesn't require the creation of a separate tip pool that would be shared, then your argument that the title is misleading, it might be if a particular employer decided to create a separate tip pool, but it may not be if a particular employer didn't. So why doesn't that affect your argument that the title is misleading?
Because the title still doesn't identify for the voter. Even the diligent voter who reads this and reads the summary, it doesn't identify the implications of Section 6. It doesn't say that even though we're promising you the full minimum wage with tips on top, Section 6 says actually, if your employer decides to and forego the tip credit, they can actually take those tips on top away. And actually, and according to Section 6, maybe some wages too.
The summary includes the last section. If you read the summary, it indicates that this sharing of tips is possible, right?
It suggests that the sharing of tips is possible, but it doesn't fully inform the voter about what the implications of that sharing of tips are. It doesn't, and even if it did, it still represents a separate policy consideration for the voters. So even, and this is why we haven't specifically challenged the summary, because it's a relatively clear and straightforward summary of what's being presented. The problem is that what's being presented are two separate issues for the voters to decide, two separate questions with only one vote. And that's exactly what the relatedness requirement prohibits.
Isn't it just like the marijuana? I mean, you could have had medical marijuana alone, but you're legalizing marijuana. Those are people who needed the medical marijuana may have voted one way and been opposed to legalizing marijuana in another. But we still found it related because the voters could understand the overall policy decision. Here, can't the voters understand the overall policy decision? We're changing the tips law. We're going to require minimum wage, but we're going to pool the things. That's your average Joe going to the poll can understand that, can't they?
Well, I certainly don't. And the first time I read it, I didn't quite understand
You're quite smart, Mr. Daly. You understand that.
I didn't understand, and the purpose that's been articulated in the AG's brief is that there's this two-tier wage structure, and the purpose is to go after and dismantle that two-tier wage structure. I don't see anything about a two-tier wage structure in the petition, but even if that were the case, and you were to accept that purpose, that only furthers the provisions 1 through 5, because that's what gets rid of the two-tier wage structure. It still has nothing to do with provision 6. And again, because these are two separate questions, or at least two separate questions, posed to the voters that only have one vote on the matter, it should not be certified and put on the ballot for 2024.
Okay, thank
Rest
you.
of my briefs, thank you.
Okay, Attorney Fisher-Groban.
Good morning, Your Honors, and may it please the Court. Phoebe Fisher-Groban, Assistant Attorney General, on behalf of the Attorney General and the Secretary of the Commonwealth. The Attorney General properly certified this petition under Article 48 because it makes two closely connected changes to how workers in tipped industries are paid for their work, their hourly cash wage and their tips. And in response to some questions to Appellant's counsel, the Massachusetts Teachers Association case says that what this court does in ascertaining whether there's a common purpose is it looks as what the provisions of the initiative petition or the proposed law would do and determines whether there's a reasonable relationship between those provisions. Here, there's a reasonable relationship between these provisions. They govern the two core components of what employees in the same business make, their hourly cash wage, and whether it's the minimum wage or a sub-minimum wage, and then whether they get a share of tips on top of what their employer pays them. And this law would allow tip pools to be administered between front of house and back of house workers. So these are,
I'm sorry to interrupt.
of course.
So what I understand you to have just said is that to determine whether there's a common purpose, you look at the entirety of the provisions of the initiative, and from that you make this evaluation. You don't just look at, for example, the title or perhaps the stated purpose of the initiative, if it has a stated purpose.
That's absolutely right, and that's what Massachusetts Teachers Association said. And also, when the voters go to the polls, they'll have the title, but they'll also have the summary that explains to them what this proposed law might do to see if they agree with it. And they'll also have the yes or no statement that comes alongside the proposed law that tells them again what this petition will do, not simply the title.
So is the inquiry, though, different if the question is voter confusion? In that case, and not relatedness, but voter confusion, which perhaps may be a subset of relatedness or something, but whatever, because in that case, does how the act presents itself, in other words, through its title or through its stated purpose, is that sort of a different inquiry, or is it the same that you would look at all the provisions to see if the voters would be confused?
In the voter confusion inquiry, I similarly think you'd look at all of the provisions and see if they're reasonably related to one another.
Does Massachusetts teachers say that as well?
I'm not certain if that case says that specifically, but I do know that the framers of Article 48, the purpose of the relatedness requirement is voter confusion. That was kind of the concern that the framers had. And so they developed the relatedness requirement as kind of a way of saying, well, if the provisions of a proposed law hang together and they're related and they bear a reasonable relationship to one another and they're unified by a common purpose, that's the tool we use to figure out whether voters will be confused or not.
So then in that, if I understand that framework correctly, then it's not that we would disregard the title, it's that it would be put in the mix of the entirety of the proposal to see if it somehow is enough to cause voter confusion, or whether in the entirety we would say, no, voters are not confused.
Yes, that's right, Your Honor. And here, I don't even think that's really necessary, because here we have a relatively straightforward proposed law that does two things. And we don't have a single subjects requirement here in Massachusetts. That is, petitioners don't have to kind of submit subjects to the voters piecemeal every 2 years.
We don't have a single subject, but it's not just voter confusion we're focused on. We want them to have a unified policy to vote on. We don't want them to have to take a vote that's internally inconsistent with each other, right? We don't want them to have to choose, but to vote once, because they, unlike a legislature, they can't amend and get rid of things. We want to make sure that it's a coherent vote. It's not just confusion. That's a separate part of it, right?
That's true, Your Honor. And here, there is a unified statement of public policy, which is allowing all employees in tipped industries to be paid the state minimum wage plus a share of tips. It removes the two statutes, or it modifies or changes the two statutes that currently prevent that from happening. It eliminates those two barriers.
Does the fact here, so both the bill, the initiative, and the summary, 5/6 of it's devoted to tips, right? And not in the last provision in the bill and the last provision in the summary deal with the sharing of the tips, right?
I think the whole proposed law is about tips. It's about what your employer can do with your tips.
Right. Their focus is that the second part, the second decision's an important one, but it only appears in one section, and the last that it's somehow getting lost, maybe. Is that, say something important doesn't come out. Does that matter? I mean, I take it your answer here is, it is in the summary, one sentence in the summary, and it's the sixth provision they read, so they do notice it. But I don't know. It just, I worry that when you bury something new in one section and it's not in the summary, that might be a problem, right?
Well, if it weren't in the summary, that could potentially pose a problem, but it is here. This is a relatively straightforward law. It's a short law. It kind of combines these two subjects, which of course it permissibly can do under Article 48, and it's right there in the summary. So this proposed law doesn't present a situation where an important provision is either ambiguous or difficult to understand or buried somewhere in a really long law. That's not this proposed law. And here, this is easy for voters to understand and to vote yes or no on. Yes, I want all employees in tipped businesses to be paid the state minimum wage plus have the chance to get a share of tips, or no, I don't want that.
So do you, I mean, the amendment to I've just glancingly gone through Chapter 149, but do you agree that the Section 6 proposed amendment to Section 152A of Chapter 149 affects all tipped employees? In other words, not just restaurant workers, service employees, of whatever sort, your hairdresser, your Uber driver?
Well, without wading into the Uber driver
Sure,
question.
but I'm just looking, I just
Thank you.
want, I just want to understand. You agree with the statement that the amendment to Chapter 149, Section 152A of Chapter 149 applies beyond restaurant workers?
Yes, that's absolutely right. And currently it does too. It's
Yes, that's what I saw too. So this amendment goes beyond the restaurant industry.
When I look at Section 6, actually how it's drafted of the proposed law, and this is on page 46 of the addendum to our brief as well as in other places, Section 6 provides that provided an employer is paying all employees a wage that's not less than the full minimum wage, they may require waitstaff employees, or service bartenders, so those are the categories of employees it would apply to, participate in a tip pool through which the tips are then distributed to employees that are not those employees.
So service employees, as I read, as defined in Chapter 149, include many other industries beyond restaurant workers. So are we saying the same thing, that this proposed amendment extends beyond the restaurant industry?
Yes, when I look at these two laws together, I see that they both use the waitstaff employee, service employee, or service bartender language.
They do. Service employees, I think, includes, I'm just, hairdressers, anyone else you would provide a tip to, which includes cab drivers, Uber drivers, all sorts of people. So does this matter? I'm not sure it matters, but it does seem to me to perhaps be beyond what, well, do you think that's fairly reflected in the summary?
Yes, I think it is, and I'm happy to take a look at the summary. But I'll also note here, though, that they have not challenged the summary here.
I
and
understand.
I do not take them to be challenging the summary.
No, they said they're not.
Exactly. And so, to me, I don't think that this poses a problem. I think we're talking about service employee industries. The most common a voter may understand is the restaurant industry, but we are talking about other industries where employees customarily receive tips. But I don't think that changes the Article 48 analysis here. Just as similarly, the tip pool prohibition applies more broadly than the restaurant industry, the removing of that prohibition will also apply more broadly than the restaurant industry. But that doesn't alter that the tip pooling provision and the tip credit provisions are closely connected here. And I'll point even that the Department of Labor obviously regulates these same issues, and their regulation related to tip pooling does exactly what this law would do, which is to say, it says if you're taking a tip credit, you can't have a tip pool with back-of-house workers. Employers that do take a tip credit, that do not take a tip credit, can have a tip pool that includes back-of-house workers. So in the Department of Labor's regulation, these are closely connected concepts, and they are in this proposed law as well. I'll make one final point, but of course I'm happy to answer other questions, which is that the tip pooling provision could also be looked at as addressing a reasonable foreseeable consequence of the tip credit provision, and it falls into the cases like Oberle's, Colpack, and Wiener, where we have the tip credit provision removes the key justification for limiting the tip pool to front of house workers, and so now once everybody's making the same minimum wage and being paid that directly by their employer, it makes sense to permit employers then not to restrict the tip pool so that the back of house workers can participate as well.